was placed on the record today, and I'll send a letter following up regarding same is the discovery that's been received by the state. They did send us all of the documentation regarding the infotainment center with the download. However, in order to do a proper evaluation and examination, we need a download of the actual, and I'll send this to the state, but it's a .ive file or raw data directly onto a USB flash drive. If we try to do what we have done in the past, downloading it through the portal, it doesn't work when they go to run it through. So I need the state police to actually place it onto a flash drive, the raw data, in the form of an IVE
But I'm not on there. Yeah.
file, and forward that. Everything else is done regarding the accident reconstruction as opposed to that. And Judge, there has been based upon the reading of the BAC being done by way of the plasma, there has been a notice of motion to dismiss for this to be represented to the grand jury with regard to that. That motion was filed yesterday.
Judge, if I may, for the record, it's Mr. Portella or Matt Portella. Judge, I just want to confirm with Mr. Higgins that he can hear us and see us because a guard just walked into the booth. Judge, can we just inquire of Mr. Higgins?
Okay. Can you hear me?
Yeah, we can hear you, Sean. Can you
No, I'm
hear us?
sorry.
Yes, sir.
I didn't, so I can't see you. It's just a black screen. I didn't know if I was on.
No,
Yeah.
you're in. Can you hear us though?
I can hear you. Yep.
All right, perfect. Thanks. Thanks, Sean. Sorry, Judge.
Thanks. So, Mr. Higgins, we can hear and see you, sir.
Okay.
So, Mr. Kleinberger, you're indicating to the court that a recent motion to dismiss the entire indictment or just certain counts of
Well,
the indictment?
Judge, at first it was going to be, it's funny you say that, it was going to be just for the counts regarding, but the issue comes with it, and upon retrospect, I filed it for the entire indictment based upon this. If the grand jury heard that the reading was a .087, and when in actuality that was done based upon the plasma, and I mean, this is science, this isn't something that's speculative. There's a mathematical formula that's utilized for this, and the actual reading is a .075. Therefore, we don't know how much that impacted the jury when it came to the grand jury when it came to other aspects of the case. Was this guy so drunk that he did this? It taints it. For this, to err on the side of caution, I filed it as a total motion to dismiss, but it might not apply to everything, Judge.
So, Mr. Mestern, have you received a copy of this report?
I received it late on Thursday. I was in court all day on Friday, in court yesterday, so I've seen it. I haven't really delved too deep into it. But I will be reaching out to those that did the analysis of the blood to get their opinions on it.
And thank you, Mr. Mestern. If you'll refresh the court's recollection, when this matter was presented to the grand jury, I do recall BAC levels being presented. Is that accurate?
Yes.
All right. So, assuming for the purposes of argument's sake that Mr. Kleinberger's expert and his analysis is accurate, would this be something that the state would be looking to represent?
If it's accurate, but I'm not conceding that point.
I said assuming. I didn't say it
Yeah.
was. All right. So
It wouldn't touch upon the entire indictment.
no, but as to particular counts, it may.
Maybe.
So what I'm going to suggest, counsel, is that I'm not going to ask you to file briefs or anything at all at this time regarding your motion. We're going to hold the motion in abeyance. Mr. Mestern, I'll give you an opportunity to discuss this with any state police experts that you believe are appropriate to review the blood draw, or any outside experts you believe are appropriate to review, I should say, the blood or plasma analysis. If you come to the determination that based upon the information presented, that it's appropriate to represent the matter to the grand jury with the BAC as reflected in the defense expert report, the court will allow that to happen. If you decide that it's something that you're not interested in doing, obviously, then I'll schedule a briefing schedule asking the defendants to file briefs, and then you can respond to their brief. Does that sound reasonable?
Um, it does, Your Honor. I think it would be more prudent to do the briefing schedule now, and then if I do the analysis and decide to represent it, I can let the court know and defense counsel know, and that would void any kind of briefing necessary. But just to get the ball rolling on that, it might be more prudent to do it that way.
Yeah. Well, my only concern was obviously if we could avoid creating more work and having more additional briefs filed, if your office is going to merely represent the matter, I'd rather hold off on those briefs. So I'm going to hold that Mr. Kleinberger, Mr. Portello's motion in abeyance at this time. I'm not going to ask that they file any briefs, but I am going to ask that if we can get a quick turnaround from your office's position with regard to the defense expert, that would be helpful.
Very well, Your Honor.
Now to the next issue that we briefly talked about, and we've been talking about for the last year plus, has the defense proffered a counteroffer? And I'm not asking you to place it on the record at this point, but have you actually presented a counteroffer to the state at this time?
Judge, we have presented the counteroffer. We'll put it in writing, sent it to Mr. Mestern. We emailed it this morning, Judge. And we won't put the terms on the record, Judge, but we did include the extensive research that we did for other cases that are similar factually to Mr. Higgins's matter and the results that came about by virtue of plea bargaining with the state, Judge. And that is a 4-page letter that has that information in it for the state to keep in mind and to frame it in terms of our counteroffer, what the state has done and what offers it has given to similarly situated defendants on their cases in the past.
All right, thank you, Mr. Portello. Mr. Mestern, you are in possession of that document.
I am, Your Honor.
And obviously, I would ask that we discuss this further with the understanding that given the fact that now the defense has actually provided a counteroffer, which had not existed up until this point, it may also obviate the need to either represent the matter or litigate the motion. So I'll leave that to counsel to discuss between themselves. If the counsel feels as though the court needs to engage or involve itself in plea negotiations, obviously the court would be happy to entertain that, but I'll leave those discussions to happen between yourselves. Okay, counsel?
Thank you, Judge.
Judge, just can we get an idea as to turnaround for that the download? Like I said, the state did provide the, I guess it's the text data, the way it downloads to the portal. You can't utilize that for running a test. So, for example, in a colloquial term, I would view it as it's like looking at a strand of code. So, they could attempt to recreate it, but it's not going to be accurate in order for them to say that it was the exact copy. So all we need is and I'll send it to the state as soon as we're off, but it's the exact copy of the raw data or it's called an IVE file.
Mr. Mestern, are you familiar with that?
I believe there was a thumb drive sent out in the initial discovery or sometime thereafter. But if I can get a letter with the specifics from counsel, and that way I can submit it to the state to police to see, it's a technical aspect that is outside the realm of my expertise. And so I'll reach out to the state police for them to take a look at the request.
All right, Mr. Kleinberger, you'll follow up in writing then.
As soon as we're done, Judge, I have it waiting here. I just want to place it on the record first before I sent it out. That's all.
All right, yeah, it sounds like a technical issue. Obviously, I don't expect Mr. Messern to be completely familiar with that. So once he speaks to the parties at the state police who may have further knowledge in that area, if they can provide that, I'm sure he will absolutely get that for you and turn it over as it is discoverable. So, counsel, other than what we've discussed, is there any other issue that any of the parties would like to address at this point?
No, Judge.
No, Judge,
Yeah.
thank you.
All right. So this was listed for a discretionary conference today. I'm inclined to move it to the pretrial conference list as we've had significant movement at this point with regard to counteroffer as well as expert reports at least being available regarding the blood draw and soon to be available regarding the accident reconstruction. I'll just ask counsel, how long do you think you're going to want to have before we bring it back for our first PTC? I'll start with the defense.
It depends, Judge, on the motion to dismiss what's going on with that.
And how quickly we can get the additional discovery from the state police if they're going to turn it over.
Right, which is going to take some time, I would suspect, Mr. Mestern.
Well, Your Honor, with the motion to dismiss, hopefully we'll have an answer to counsel and Your Honor within a week. With regards to the information, the technical information, I'm not too sure. Maybe a week and a half, 2 weeks for that. I'm not too sure if their defense expert, is going to need time to digest and do a report. It seems like he hasn't really done much with the data that was provided. So
We have a report done already, Judge. That's the last piece needed. We utilize the everything else that was there on scene. So we have a report done. This is the only piece that's missing. My expert did not feel comfortable putting forth the report unless they can compare the data that was received from the state in the form of the copy of the download to an actual download. That's it. That's the last thing. So once we have that, that's it. But I could tell the court that there is issues, factual issues that will be brought up already, but we just want to make sure that the T's are crossed and the I's are dotted here.
Understood, Mr. Kleinberger. So I suspect a return date of bringing it back on March 10th will be premature, probably a little too soon.
Probably too early.
Yeah, Judge. And I'm not available that day either. Yeah.
Okay, give me a moment.
Judge, would this be for a status type date to see where we are with regard to the state representing or not and
Well,
the discovery?
so we're actually going to move it to a pretrial conference with regard to all those other things. They should occur between today's date and the next date. I don't see any reason why things cannot get done between counsel. If things need to be addressed sometime with the court, you can just reach out to the court, and I'd be happy to conduct, an in-camera conference at that point. But I'm looking at now a return date if everything works out with council schedules of April the 7th.
I am available that day.
Judge, could we do 1:30 on that day?
We can absolutely do one.
Thank you.
Your Honor, I'm not available that day.
Oh, sorry, Mr. Mestern, you're not available. All right. Let's take a look then at some other dates. How about in the PM on Friday the 10th?
That whole week I'm out.
Oh, you're out that whole week?
That's
Okay.
my birthday, Judge. But I'm out.
We don't want to disrupt your birthday, Mr. Portella.
Yeah, I'll be out.
All right. Let's look at then Tuesday the 14th.
That works, Judge.
1:30?
I have jury duty. If I get
You have jury duty.
selected, but
Well, the question is whether you even get called in for jury duty.
yeah,
And
but
I'm sure if you let the court know that you have a scheduled mandatory court appearance on that date, that they would excuse you for that day.
Judge, I'll call the jury management on that. Good excuse to get out of it, right?
Well, I mean, we're not looking to get you an excuse to get out of it, but on that particular day,
Just
I'm sure
that
they
day,
can
Judge, yeah.
I'm sure they can reschedule you for another day, Mr. Portella.
I'll take care of that today, Judge.
So we go for 4/14 at 1:30 p.m. And Mr. Mester, that works for you?
That should work for me. I have a trial scheduled for that week, but um, you know, I'll once we get closer, I'll have a better idea as to whether
Yeah, I
I'm
mean
actually in front of the
that's
jury.
a month and a half from now, so we don't you never know what's going to happen between now and then.